who did not testify in that pretrial hearing but testified later, was very compelling about those levels of injury and their different states of healing. Kids get bumps and bruises. Corey had more than bumps and bruises that you would see on a 6-year-old. So for all the foregoing reasons, I conclude the imposition of a consecutive sentence is overall fair under the circumstances of this case. The state's taken an additional position that I should impose the least restrictive or flat prison sentence first, such that it precedes the more restrictive prison sentence, meaning that the defendant should serve the endangering sentence before the aggravated manslaughter sentence. There's a very difficult legal analysis associated with that. I rely upon State versus Ellis. It's an television case from 2002, 346 New Jersey Super 583. And a Supreme Court opinion in State versus Pierce, P-I-E-R-C-E, 220 New Jersey 205, an Supreme Court decision from 2014. It is legally possible. In fact, what the Ellis case says is, while it's not illegal, it's difficult to justify. And it typically runs afoul of certain sentencing guidelines, and it may interfere with the expertise of the parole board. The defendant should be released on parole. And based upon both of those decisions, I conclude that I cannot impose the least restrictive sentence first without engaging in an abuse of discretion. So therefore, I direct that the No Early Release Act sentence on the aggravated manslaughter count run first, followed by the flat sentence on the endangering count, such that the aggregate sentence is 25 years and that the jail credit of 885 days comes off the aggregate sentence. Another condition of the No Early Release Act is that defendant shall serve a 5-year period of parole supervision upon release, that he shall provide a DNA sample and pay for the cost the same. There are 2 $50 victim of crime compensation assessments, 2 $75 safe neighborhood assessments, 1 $30 law enforcement training and equipment fee. The superintendent of the institution where defendant is incarcerated shall draw sufficient monies in an amount not to exceed 1/3 of the inmate's total income as may be required to pay these assessments. The Office of the Victim of Crime Compensation Board submitted a request for restitution for funeral expenses. There's been testimony during the course of the case about whether or not defendant's parents paid for funeral expenses, whether or not the Ms. Micciolo's family paid for them through the VCCO office. I've considered, am I supposed to hold a hearing on that? And I conclude that the parties need closure in this matter. They don't need another hearing on whether or not those expenses actually went to the funeral, or and the VCCO letters also refers to some other expenses not associated with the funeral that may not be directly attributable to defendant's conduct. If these were out-of-pocket expenses by anyone qualifying as the victim, I'd be inclined to consider them further. The Office of the Victim of Crime Compensation Board exists for the benefit of victims. It charges, the defendants are assessed, like this defendant's been assessed, 2 penalties for that, to fund that, and I conclude at this point that it's not appropriate to order that restitution because of the questions concerning who paid for the funeral, and more importantly, I would have to do an analysis of the defendant's ability to pay now or in the future. He's been incarcerated for the last 885 days. He's been unemployed. He clearly has no ability to pay now, and he has little ability to pay for the next 25 years. So I conclude for those reasons that mitigating factor 6 is not present. There's no restitution to be paid, no ability to pay restitution. Therefore, I do not order restitution. If there's any bail in this matter, it's discharged. There are no dismissals. Madam Clerk, is there anything else I need to address? And Mr. Gallucci, we get his appeal rights form? All right. Anything further from counsel?
No, Your Honor.
No,
All right.
Judge, thank you.
Thank you, everyone, for your excellent presentations. That concludes the matter.
Thank you.
All right.
Wait, do not exit yet. The back row is going to exit first.
All right, well, that concludes the sentencing hearing of Christopher Gregor. The judge has to run through
all of these sort of technical points. You know, on top of the 25 years of sentencing he imposed, he has to consider fines, some of which he imposed, possible restitution for funeral expenses, which he didn't impose based on the unlikelihood that the defendant has any ability to pay that. He's got to go through all of that, which may seem a little anticlimactic in a hearing like this, which started out with very powerful, very emotional statements from the victims, from the grandparents of the child, from the mother of the child, and then the imposition of a 20-year sentence for manslaughter, a 5-year sentence for child endangerment, those two sentences to run consecutively, so a total of 25 years. We're going to take a quick break. We're going to come back and check in on the young thug Rico trial and see what's going on there. Don't go away.